Hello friends, in today's session we are going to discuss the case of state of Madhya Pradesh versus Mubarak Ali. Let us first understand this case briefly. In the case of state of Madhya Pradesh versus Mr. Mubarak Ali, the assistant station master Mubarak Ali from Gwalior in Madhya Pradesh was accused of accepting a bribe. Mr. Mohindernath Bhalla, the manager of Daisy Swing Machine Company Limited, informed the police that Mubarak Ali had demanded a bribe in exchange for booking goods at the railway station. The police sub-inspector registered a report under section 161 of the IPC and the Prevention of Corruption Act 1947, treating the act of bribery as a punishable offence. However, the High Court observed that there was a procedural flaw in granting permission for investigation, as the magistrate had granted it without properly examining the available evidence. The Supreme Court upheld this view, stating that before commencing an investigation, the magistrate must thoroughly scrutinize the evidence and strict adherence in Section 5A of the Prevention of Corruption Act is necessary. It was also established in this case that no investigation can begin without proper authorization. Now let us study this case in detail. Answer: State of Madhya Pradesh Appellant versus Mr. Mubarak Ali Respondent. Reference AIR 1959 SC 707. Subject of the case. The case relates to Section 41 of the Code of Criminal Procedure 1898, Section 120B and 161 of the IPC and Section 5A and 52 of the Prevention of Corruption Act 1947. Case facts: in Bhopal, the capital of Madhya Pradesh, there was a company named Daisy Swing Machine Company Limited, managed by Mr. Mohindernath Bhalla. On January 11, 1955, Mr. Bhalla informed a sub-inspector of the special police establishment in Gwalior that he had gone to the Gwalior fair to send empty cases and parts of swing machines to New Delhi via the railway station. When he contacted the assistant station master regarding booking, the assistant station master demanded a bribe of 10 anna per case for booking. After negotiations, they agreed on 8 anna per case, and he was asked to bring the goods between 2 p.m. and 4 p.m. Mr. Bhalla submitted a typed and signed complaint, which was verified by 2 witnesses, to the sub-inspector. The sub-inspector provided Mr. Bhalla with the amount of money intended as a bribe. Following the pre-arranged plan, Mr. Bhalla handed over the money to the assistant station master and signaled the police who were standing outside. The sub-inspector went to the office, identified himself, and in the presence of witness requested the money back that the assistant station master had taken as a bribe. The station master identified himself and returned the amount. The sub-inspector counted the money and verified the serial numbers. A search of the assistant station master was conducted and all seized items were prepared into a memorandum. The police sub-inspector concluded that the actions of the assistant station master and the pointsman Moolchand were punishable under Section 120B, 161 of the IPC and Section 52 of the Prevention of Corruption Act 1947. He sent a report including all facts to the Special Police Establishment Office, which was registered on January 14, 1955. 7 days later, on January 21, 1955, the sub-inspector submitted an application to the Additional District Magistrate Judicial in Gwalior seeking permission to investigate the crime under the above sections. Trial Court. On October 1, 1955, the charge sheet was presented before the Special Judge Anti-Corruption, Indore. During the trial, the defendant raised an objection that the permission given by the Additional District Magistrate for the investigation was not legally valid. The special court was ready to take evidence, but the prosecution requested a postponement, stating that in a similar case where the prosecution was directed to present evidence, an appeal against the order was pending in the High Court. On this basis, the special judge granted a 3-week stay on December 3, 1955, stating that the Special Police Establishment Office had no objection. Later, on August 21, 1957, the special judge acquitted the pointsman Mool Chand and charged the defendant Mubarak Ali under Section 161 of the Indian Penal Code. In the same order, the objection raised by the accused regarding the permission for investigation given by the additional district magistrate was also rejected. High Court. On August 21, 1957, the defendant filed a revision petition in the High Court against the order passed by the special judge. After hearing the case, the High Court found that the police sub-inspector had applied for permission to investigate 10 days after beginning the investigation. Furthermore, the additional district magistrate did not make any attempt to verify if there was a valid and sufficient reason for granting permission to a subordinate officer to conduct the investigation. The magistrate had granted the permission as a routine matter without any consideration. On this basis, the High Court set aside the order of the special judge and directed the magistrate to grant permission to the deputy superintendent of the police to conduct the investigation to correct the flaws and legal deficiencies in the process. Supreme Court. The state's statement position before the Supreme Court. A. It was not justified for the High Court to conclude that the magistrate granted permission to the police sub-inspector to investigate the case without satisfying himself and only as a routine matter. B. The High Court's assumption that the investigation had begun 10 days before the magistrate granted permission was wrong. To examine the first objection, the Supreme Court reviewed Section 3 of the Prevention of Corruption Act 1947, which was effective even before the Amendment Act of 1955, and Section 4. Section 3 states that offences punishable under Section 161, 165 or 165A of the Indian Penal Code are considered cognizable offences under the Criminal Procedure Code 1898. Section 4 deals with bribery and illegal gratification. The Act was later amended to add Section 5A and 6 providing safeguards for public servants. These sections state that in places like the Presidency towns of Madras and Calcutta, only an assistant police commissioner in Bombay, a police superintendent, and below the rank of deputy superintendent of police in other places can investigate crimes under these sections unless prior permission is obtained from the relevant government. The Supreme Court further clarified that these protective provisions must be strictly adhered to before granting permission for an investigation. The first-class magistrate should thoroughly examine the evidence presented and satisfy himself. A magistrate must exercise judicial direction independently and cannot be bound by any police officer's statement or requests. The magistrate must review the available evidence and make a decision after proper consideration. The Supreme Court also referred to earlier decision emphasized the independent use of judicial discretion. The Supreme Court noted that in this case the defendant had raised an objection in the initial stage, that is in 1955, that the permission for investigation granted by the magistrate was illegally given. However, the prosecution failed to present any solid evidence in support of the magistrate's order. Only the police sub-inspector's application was submitted, on which the magistrate issued a brief order stating permission granted. The prosecution delayed submitting a petition in the High Court seeking an opportunity to present evidence supporting the magistrate's order, which the High Court rightly rejected. The Supreme Court also accepted that the High Court's view was entirely correct that Section 5A of the Prevention of Corruption Act 1947 was not strictly followed in this case. Regarding the second objection, the Supreme Court agreed with the High Court's finding that the investigation had begun 10 days before permission was sought, as the police sub-inspector had started the investigation on January 11, 1955 and had already submitted a report to the special police establishment office in Indore. However, the application for investigation permission was made on January 21, 1955. This clearly indicated that the investigation initiated by the police sub-inspector was faulty. Based on this, the Supreme Court dismissed the appeal. Legal principle laid down. In this case, Supreme Court established the following legal principle. First, an investigation into a public servant's bribery cannot be conducted by a police officer below the rank of Deputy Superintendent of Police. Second, prior permission from a first-class magistrate is required before conducting an investigation. Third, the legal safeguard provided under Section 5A of the Prevention of Corruption Act must be strictly followed as they protect public interest and serve as a guarantee against trivial or vexatious prosecutions. Fourth, an investigation begins only when a police officer receives information about a crime. Please watch full video, share and subscribe to the channel. Thank you.